Here we go. Okay, well, hey everybody. Thanks for joining this first Brooklyn Project Open Roundtable. It's our first one. It's a bit of an experiment. We'll see how this goes. We've got a lot of kind of important and difficult topics that I know are kind of on the table from a legal regulatory policy perspective, and so we've got a short amount of time to talk through these. We'll do the best we can. We'll try to keep moving, try to answer questions, try to have an open discussion, get thoughts from everybody. And it's an experiment. We'll see how this goes. One thing I'll flag, I guess, up front is, because I'm a lawyer and lawyers are no fun, we really want to have an open kind of brainstorming discussion. So, as a result, I think we all need to just assume and understand that people are speaking in their personal capacities and not on behalf of law firms, companies, or anything like that. So we'll be kind of brainstorming in our personal capacities here about these topics. I'm going to put the, I don't know if everybody saw the agenda we posted. I'll here in the chat too, so you can follow along. Oh, I see Lewis.
Hey, Lewis.
Hey, Lewis. So I just put a link to the agenda in the chat there. Feel free to follow along. The first thing that we wanted to talk about was Director Hinman's recent speech and kind of the intersection of consumers, investors, tokens, and decentralization. I think Aaron was going to kick us off on that. So Aaron, take it away.
Yeah, sure. And thanks, Pat. And nice to meet everybody. If I haven't met you already. So listen, we had a big speech from the current director of the SEC Corporation Finance, which is the group that's responsible in part for setting policy for the SEC. And it was a pretty big deal for the space because it was the first time that we saw substantive information about how the current SEC is going to view blockchain-based token sales. So just to set the stage and give some context, right? We all know, or I think many people here know, that token sales exploded in 2017. There was something like $3.6 billion in tokens sold in 2017 alone. This year we're seeing continued growth, due in large part to a couple large sales, but it's something like eclipsing $16 billion this year. And we've seen, as these token sales have grown, questions and concerns raised by regulators as to whether or not this emerging financing practice raises potential securities laws violations. So in July 2017, the SEC issued a 21A report concerning the DAO, where they flagged some concerns that the DAO's underlying token was a security, at least in their view, at that time. And then following that report, we've seen a ramp up in enforcement by the SEC, with the agency bringing actions against a number of companies that have raised money through token sales. And we've also at least had reports that supplementing the SEC's enforcement actions were a number of subpoenas that have been issued to token sellers. And according to the Wall Street Journal, that number was quite large, up to 80 plus subpoenas. So beyond these enforcement actions and subpoenas, the SEC Chairman Jay Clayton has made a number of public statements regarding cryptocurrencies and token sales, including doing some unprecedented things like issuing a joint op-ed with the CFTC commissioner that appeared in the Wall Street Journal, calling out intermediaries and raising concerns about what we were seeing in the marketplace. And each of these statements seemingly emphasized that when investors in a token sale had an expectation of a return on their investment from the promoter's efforts, then at least in the SEC's view, those digital asset sales implicated and would require the application of federal securities laws. But on June 14th, Director Hinman issued a statement that provided for further clarity as to how the SEC will view the sale of blockchain-based tokens, delivering a speech that really provided further guidance on the circumstances surrounding when the sale of a digital asset may qualify as an offering or selling of a security. So I think it's important for those that have read it and for those that have not read it to understand that these statements are not legally binding. They really just provide a clue into how the current SEC will view token sales. And they'll be persuasive with courts if and when they grapple with these questions going forward. So this is not necessarily the law. This is not something that's been enacted by Congress or some sort of ruling that a federal court that has some binding authority has issued. So this is really just clues into what the current view of the SEC is thinking about. And at least in my view, the speech seemingly outlined two potential paths forward for the sale of blockchain-based tokens, and really provided more detail on how the SEC staff will determine whether the sale of the token will implicate federal securities laws. And the big thing, and this is not surprising to securities lawyers, really in alignment with existing precedent, the inquiry, at least according to him in speech, will not hinge on labels used to describe a blockchain-based token, things like utility tokens or consumer tokens, but really will hinge on the economic realities of the transaction and how the digital assets are issued, structured, distributed, and sold. So while the digital assets in and of themselves will not be deemed securities, and Hinman made this clear, the manner in which they're sold and the reasonable expectations of purchasers are going to play a really, really big role here, and potentially a determinative one. And so consistent with those previous statements from the SEC, Director Hinman clarified that today, many existing token sales appear to implicate federal securities laws because they involve the sale of tokens to investors. And promoters of blockchain-based projects that raise money through token sales to develop networks that rely on these digital assets will likely have characteristics that resemble the share of stock or other securities. And early stage companies that are choosing to engage in token sales, in effect, using these token sales like a seed or Series A round of financing, run the risk that those tokens will be deemed securities. So, if, according to Hinman, promoters of the token sales effectively promise passive purchasers that the money that they're providing will be used to generate a future return on the digital asset, regardless of its label, it's going to be deemed an investment contract or security under federal laws. And what was interesting here in the statement, which was particularly notable, is that Director Hinman outlined a number of questions related to whether or not a token will be deemed a security. And in laying out these factors, Hinman emphasized the need to focus on the economic realities of the transaction and articulated 6 non-exclusive and non-exhaustive factors to guide the analysis. And so some of these are not surprising, but I think they're worth just pausing on. The first one was, is there a person or a group that sponsored or promoted the creation and sale of the digital asset, the efforts of whom play a significant role in the development and maintenance of the asset and its potential increase in value. The second one was whether a person or group retained a stake or other interest in the digital asset such that it would be motivated to expend efforts to cause an increase in value in the digital asset. Would the purchasers reasonably believe such efforts will be undertaken and may result in a return of their investment in the digital asset? The third one was, has the promoter raised an amount of funds in excess of what may be needed to establish a functional network? And if so, has it indicated how those funds may be used to support the value of the token or to increase the value of the enterprise? So in other words, does the promoter continue to expend those, did the promoter raise more than what was necessary? So if you did a $200 million token sale, and you really only needed about $5 to $10 million to build a useful product, that may indicate that what you sold was a security. And related to that is, does the promoter continue to expend funds from proceeds or operations to enhance the functionality and or value of the system within which the token operates? The fourth one was, are purchasers investing or seeking a return? In that regard, is the instrument marketed and sold to the general public instead of potential users of the network, and such that the price reasonably correlates with the market value of the good or service in the network? The fifth one is kind of a common sense application of whether or not the Securities Act protections make sense. Is there a person or entity or others that are relying, that those are relying on that plays a key are relevant? And the last one, I think my internet just kicked out, apologies. And the last one was, do persons or entities other than the promoter exercise governance rights or meaningful influence? And that one I think is going to become increasingly relevant. So again, these factors root on the economic realities of a token-based sale and focus on federal securities law analysis on questions related to the promoter's control over the project. They also center on the risk that a promoter or some other person or group of persons related to a blockchain-based project may create by retaining a material interest in the project, such that they can manipulate the price of the tokens or assets going forward. So So this is where the speech also got interesting. So beyond outlining these factors, Hinman clarified that the staff's current position appears to be that even if a token is offered as an investment contract off the bat, it doesn't necessarily mean that the token cannot be subsequently sold in a way that falls outside the scope of federal securities laws in limited circumstances. So they kind of provided clarity on this question of whether or not tokens can somehow transform or transmute. They clarified that that's not really the right question. The question is, if something is a security on day one, will be implicated as part of an investment contract, can it later be sold in a way that falls outside the scope of federal securities laws? And there, at least in Hinman's view, it seems like a token sale may fall outside the scope of securities laws if the network on which the digital asset functions is, quote, sufficiently decentralized, where purchasers no longer have a reasonable expectation that the promoter would carry out essential managerial or entrepreneurial efforts. And here, Hinman further clarified that the rationale for why you can sell something that a token related to a sufficiently decentralized network later on as not a security, because there's really no longer a need to rely on the promoter's efforts to increase the value of the digital asset, and applying the disclosure regime at that point in time just doesn't seem to add much value. And that's why he indicated that Bitcoin and Ether may not be deemed a security when it's being sold today. So that was obviously a big deal for the industry. But with that statement, again, it's not fully legally binding. It's just persuasive. And it also raised a whole host of questions, which I imagine folks are going to be grappling with over the upcoming months and years as to whether or not, when and whether or not a project is sufficiently decentralized. And what's also interesting here is that the test that Hinman was outlining about decentralization appears to be dynamic. So that means that even if something starts as decentralized, it could eventually re-centralize and potentially implicate securities law concerns. So the key inquiry, at least based on Hinman's statement, appears to be on what these essential managerial or entrepreneurial efforts are. In other words, is there evidence of central actors whose efforts are key to the success of the enterprise? So that's kind of on the one hand, just thinking about if you're selling tokens to investors, what does that mean? I think, again, in short, it means that they're likely going to be deemed securities. That's been made pretty clear both in the enforcement actions that the SEC has brought and in the public statements. And if a network becomes, quote, sufficiently decentralized, and that's still an open question as to what that means, then those tokens may be able to be sold outside the scope of securities laws. So that doesn't mean that no laws apply at that point. It just means that different laws apply. Laws that relate to the sale of commodities, consumer protection laws, a whole host of other laws will kick into effect at that point in time. But unpacking it further, and this was towards the end of the speech, Hinman also commented and recognized an alternative path, one where a party seeking to start a blockchain-based project can raise capital in a more conventional way once the network is up and running, and distribute and offer blockchain-based tokens or coins to participants who need the functionality of the network and the digital asset. So the thought here is that this is something we've explored in detail in some of the documents and principles and practices and disclosures that we've been working on in the Brooklyn project. The tokens or coins can be structured and offered in a way where it is evident that the purchaser is not making an investment in the development of the enterprise. They're really using it for a consumer purpose. So token projects here, Hinman recognized, can employ contractual or technical ways to structure digital assets so they function more like a consumer item and less like a security. And Hinman also articulated 7 factors here in determining whether a token function as a, quote, crypto good of some sort. So these, I think, again, are notable, and we'll probably see more clarity and guidance on these factors going forward. The one is the token creation commensurate with meeting the need of users, or rather with meeting speculation? Are there independent actors setting the price, or is the promoter supporting the secondary market for the asset or otherwise influencing trading? The third one is it clear that the primary motivation for purchasing the digital asset is for personal use or consumption as compared to investment? Purchasers made representations as to their consumptive as opposed to some investment intent. So that could be, again, be defined potentially contractually or in other ways through a technical form or something along those lines. Are the tokens available in increments that correlate with the consumptive versus investment intent? So, are you buying large blocks of these tokens, or really just buying what you need or what you anticipate needing? Are the tokens distributed in a way that meets users' needs? Can the token be held or transferred only in amounts that correspond to a purchaser's expected use? And are there built-in incentives that compel using the token promptly on the network, such as having the tokens degrade in value over time? Or can the tokens be held for an extended period of time for investment? So that's, I think, an interesting question, and one that raises some interesting implications. And the last three are really about the marketing and distribution. How is the asset marketed and distributed? Are the assets dispersed across a diverse user base or concentrated in the hands of a few? And is the application fully functioning in the early stages or in development? So that goes back to the security law point. Are you using this for fundraising purposes, or are you using this to kind of build up the user base? So those factors were laid out by Hinman. Again, he noted that they do not appear to be exhaustive factors, and that they don't necessarily, all these factors do not necessarily need to be present to establish a case that a token is or is not being offered as a security. And there's still open questions here as to how you can sell a quote crypto good as to consumers, and one that I think we're going to continue to see some further clarity on over the upcoming months and years. So, pulling this all together, it seems like there's really, like a couple paths forward. One is if you want to sell tokens directly to investors, you can do so, but you're going to have to hope and build the network in such a way that the token is supported by a sufficiently decentralized network. And again, that's not a defined term. It's not used in any existing case law. There's no law or statute that defines what decentralization means. So it likely will be years before we know the answer to whether or not something is sufficiently decentralized. At the same time, you should be able to structure these transactions in a more conventional way and sell these tokens directly to consumers if you have strong evidence of the fact that the consumers want to use it and are not really purchasing it for an investment intent. So this was a big deal, something that I think a lot of folks here may have heard about or have dug in deeply. So it's great progress, and I think we'll see some more interesting things coming from the SEC over the next couple months and years.
Thanks, Aaron. That's really helpful. I don't know, do we want to take any questions or thoughts now, or do we want to kind of go through the agenda and do all that at the end? What do you think?
Well, I did just roll on for about 15 minutes, and I apologize for that. So I'm happy to take questions. What do you think, Ben?
That's fine with me. We can do a few questions now or hear anybody else's comments, maybe, even if they're not questions. We can do that for a few minutes and then just make sure we kind of move on.
Yeah, this is Hector from Asari. Quick question. I threw it in the chat too, but since this is not law, this is policy. Obviously, it seems to be very well thought out, and it appears to be kind of the position of the SEC right now. But what's the risk that that a different commissioner comes in or a different regime comes into the SEC and takes a significantly different view that can kind of create risk down the road for projects that are doing this stuff right now?
I think that's a great question, Hector. I think there always is that material risk, right? Until there's a law or until there's case law that's binding. This is really just the current view of the current SEC staff. So if in 4 years or in 8 years, if in the next couple of years a new administration comes in, or if Trump is reelected, and there's a new president or new regime that comes in after that, then we could see a different approach taken to some of these person threats. But the only thing that would kind of cabin against that is, the industry will develop a little bit more. So I think we'll have a clear sense of what the risks are. So if this actually is a sensible approach, I think that there's generally an instinct for pragmatism to win in the US. So if folks see that this is working and consumers are not being harmed and that there's not undue speculation, then this may just eventually harden into law. The tricky part for lawyers, though, is until that happens, it's hard to provide advice to entrepreneurs or other folks that are developing these projects. Right. So.
One thing that I would add is, I think, generally, I think the SEC and most regulators, I think they're at least mindful of if people are following the guidance or the position of the SEC or regulators at the time when they're engaging whatever action they are. I think that counts for something, even if the later administrations want to approach an industry or topic in a different way. Obviously, there's a lot of kind of gray area, kind of on the margins of, okay, what does that mean in a particular case, and et cetera, et cetera. So, you know, it's certainly not bulletproof or foolproof, but I do think it counts for something if projects try to follow this approach as currently set out. And one other thing I would add to this is a somewhat related point. You know, one strategy I think that we have taken. Hey, if somebody's not talking, can you try to make sure you're muted? We're getting some feedback.
Yeah, thank you.
So the related point that I was going to make is, I mean, one strategy we've had with the Brooklyn project is kind of taking in mind where entrepreneurs and projects are. It's not necessarily, you know, this isn't necessarily a law school exam. It's not necessarily saying like, hey, this is like the legal argument you can make to win. Because a lot of entrepreneurs, they don't want to end up having to make a legal argument to win either in front of the SEC or a judge or an appeals court several years down the road or something like that. You know, entrepreneurs want to build stuff, they want to get off the ground, and they want to not have to worry about it. So, you know, it's trying to structure approaches that that can allow innovators to, you know, responsibly do that, and not rely on, you know, hopefully not rely on winning a legal argument down the road in a court. Obviously easier said than done, but that's kind of the goal. So, you know, just because we're kind of, if we offer thoughts that, you know, one way or another way is maybe the better way to go or a good way to go, that doesn't mean other projects can't try something different and can't succeed and can't ultimately, you know, be following the law. It just means, you know, maybe they might have to fight with a court or a judge down the road to prove that. So that's one clarification. Any other comments or questions on this topic?
I think Will had a question in the chat. But the question is, you know, does the argument that a token may fall out of securities law if it becomes sufficiently decentralized imply that the token and selling the token earlier in the life cycle of a project was at the time in violation of securities law before it became sufficiently decentralized? So that's a great question, Will. You know, I think there, it really is an open question as to whether or not the timing related to the sale of a token is going to matter. So, you know, to the extent that a token is being sold as a consumer good, I think that there's strong arguments that the token can be sold beforehand. You know, think about Kickstarter. If you're selling a good like a 3D printer, you can pre-sell that good and not run afoul of securities laws. The timing of the sale matters less than you in that instance. If, however, you're using it for fundraising purposes, it seems like the SEC, at least in the current view, may find that to be evidence of the token being used as effectively like a security, and that may indicate that it's going to qualify as an investment contract. So the answer is it's going to depend, which is I know the worst answer to provide.
Yeah, and just to be clear, I mean, I think it's always, obviously, I think we all recognize that centralized, normal companies can sell consumer items and consumer goods to people without implicating securities laws. There's obviously some kind of complications in the token or quote unquote ICO space that make the analysis more complicated here. But the core idea that you can sell a digital product and people want to use the product should apply. Any other comments or questions on this topic?
Hey, Pat, it's Lewis. Just a quick observation.
Yeah, sure. Thanks, Lewis.
You know, the Hinman speech offered at least the possibility of no action relief being provided by the staff in specific cases. And obviously, in other contexts, no action relief has been an important part of the jurisprudence to help lawyers start to extrapolate, even if your facts are not identical, to pull in a kind of an affirmative rather than negative direction. And although, you know, there have been some restructuring around the you know, who is in charge, and Valerie Stepanek has taken on a new role, there are some good reasons to believe that the staff is now moving actively toward providing no action for various projects. And look, we'll believe it when we see it, but if that does happen, I think it is worth noting that that will be another critical development in this, as we'll actually have, you know, some no action relief to work from. So just to flag that again, as and when it comes out, but you know, from our own conversations with the staff, we have some reason to be encouraged in that regard.
Yeah, thanks, Louis. That's helpful, and I agree. And I mean, I think the SEC has been very constructive in this area. So certainly for lawyers and projects on the call, that's certainly a route, and it's certainly something that I think Louis is right that eventually we'll have some more contours around all of this, probably through no action.
Yeah, the question I think just becomes, you know, whether or not after this guidance there's still demand to do that, right? And you know what the timing is of that no action release. It could take quite some time for that no action relief to be granted. Pat, I think there was one more question in the comments. I don't know if you want to take that one.
Looks like the question is, do airdrops mean that securities laws are not implicated even if the token value is dependent on the efforts of others? So this is a tough one, and I think the easiest way to answer it is it depends, which is the favorite of all lawyers. I think that I mean, speaking personally, I've been a little bit concerned. I've seen a lot of people think that, you know, if you just airdrop, all problems go away. And I think the analysis is going to be a little bit more complicated than that. But I think it is going to be kind of heavily fact dependent on, you know, the situation, the status of the tokens. I mean, if you're just doing an airdrop to people randomly, you know, that might be different than if you've sold a lot of tokens to a lot of investors and then you're doing an airdrop that seems like it's more or less kind of just giving investors liquidity. There's a lot of kind of variations and kind of, I think, the airdrop fact pattern that I could see the SEC viewing differently. But you know, that's really just kind of speculation on my part, because as I'm aware, I don't think the SEC has commented or given much indication, at least publicly, on how they are thinking about airdrops as they relate to the issues we're talking about. I don't know, Aaron or anybody else have anything to add on that?
Yeah, just one minor thing. You know, there was a couple internet-based companies during the first wave of the internet that gave away free stock. They effectively did something that could be analogized to an airdrop. And at least at that time, the SEC didn't look that favorably on such practices. So I think the jury's still out as to whether or not airdrops will implicate securities laws or not. I think, you know, at least in my opinion, usually, again, pragmatism applies here. So if it looks like consumers are being hurt or it's leading to undue speculation for certain projects, then I imagine folks would look at those practices and try to clamp them down and find legal theories and hooks to do that.
Yeah, I think that's important. I think the distinction I've heard, Aaron, with the precedent that you mentioned is that, you know, in those cases, the underlying instrument that was being airdropped was an actual clear security, and in this case, it would be a digital token that, in theory, putting aside externalities such as how it's sold and marketed, the instrument itself would not otherwise be a security. It's just kind of inherently consumptive, and so that's one of the distinctions. And but I think the fundamental point that Aaron made is right, which is, you know, think of it pragmatically. If consumers are getting hurt, if it's driving undue speculation, chances are that regulators and policymakers are going to, I think, you know, view it through that lens.
Yeah, I mean, you could view an airdrop almost as like a free giveaway of a product, right? So if that's how it's positioned, then maybe that would be deemed okay. But if it looks more like one of those distributions of an unregistered security, which is what happened back in the 90s, then that would create some problems as well. I think there's another question in the comments. You want to take this one, Pat?
Which teams do you admire in this space? Who is being really thoughtful about their token engineering? I mean, since I work at Consensus, I feel like I'm probably too biased to really answer this sufficiently. I just, I'll say that I know that kind of related to the Brooklyn project and also what we've been doing at Consensus, I think, we're really trying to do some what I think are useful and good and helpful experiments at Token Foundry in terms of how to structure tokens and sales and try to find ways to kind of cut through a lot of the immense speculation that kind of built up in the industry over the last 12 months, and try to find ways to get these digital consumer goods in the hands of people who actually want to use them and can be really valuable contributing members to the networks. Because at the end of the day, I think what is most exciting about this technology, at least from my perspective, is the ability of a network of people to kind of coordinate their activities and do some, achieve some goal, achieve some outcome. And I think getting these tokens in the hands of the people who can, add that value to a network and be those useful members of a network is really important. And it's in my opinion, it's currently a bit difficult to do. Oh, thanks, Richard. Any other comments or questions on this topic before we move on? Looks like no. Okay, so let's move on. I think the next item on the agenda was the token taxonomy. I will try to copy the link and put that in the chat so everybody can access it quickly. I think we can be relatively quick on this unless people have comments or feedback that they want to talk about. We put together a brief kind of token taxonomy, the idea being, let's just find a way to kind of label and orient people's thinking around these digital tokens. In our opinion, we thought that a label of kind of consumer token was more helpful than utility token. And the reason why we kind of thought that originally was, I think really the reason was kind of borne out a bit by Director Hinman's comments, which is, I think, really some important parts of legal inquiries are going to turn on whether something is being sold as a consumer item versus an investment. And also the second reason why we took that route was related to what I just said a moment ago, which is I think fundamentally it's going to be the consumers and users that are going to drive the useful activity on networks, and then ultimately the network effects. And so we kind of wanted to orient to that fact and this idea of consumers or users, as opposed to just kind of functionality or utility of a digital instrument. Oops, sorry, my dog is barking. We've got some public feedback on the taxonomy. We're in the process of working through that still, and we do plan to kind of finalize the next draft or version of it. The one notable comment, I guess, that we'll note here before we open up the comment is just, I think we are currently contemplating that we'll add another aspect to the taxonomy. So currently the taxonomy just involves, 3 labels from the perspective of securities laws. We're thinking that another kind of layer or perspective for labels or taxonomy that might be helpful is kind of like a technology perspective or technology layer. And in that layer, we would envision something basic like, app tokens and protocol tokens. And the thinking there is that, especially as, interest and attention focuses on this idea of what is or is not, quote unquote, sufficiently decentralized, we anticipate that part of that is going to turn on, or at least be related to whether a token is an app token or a protocol token, and the distinction being, an app token is more like a coupon that a particular company would sell to its customers or something like that, whereas a protocol token is, something like Ethereum or Bitcoin that people can kind of like build on or use on kind of a protocol layer. There's no kind of central company or app. I don't know, Aaron, do you have anything to add, or otherwise open up and see if people have comments or feedback?
No, yeah, I mean, I think that could be a helpful dimension. I know it's something that at least I've debated internally in my mind. but I do think that assuming that kind of the framework that Hinman laid out in his speech becomes adopted, there's going to be a distinction between networks that are aiming to be not controlled by any one party, and or decentralized, that support a whole host of applications or services or other blockchain-based products, and those that are kind of used internally within one single centrally maintained service. So I think that that's a worthy dimension to begin to explore. And I think the risk that we face now is that if the argument is that more and more things will rely on these token-based systems, they won't just be decentralized, distributed, open source protocols that folks are going to be building. They'll probably also be incorporated by more traditional businesses as part of their day-to-day operations, so that they could take advantage of things like crypto economics or other incentive systems that blockchains seem to do better than others. So that's kind of our why this question is coming up.
Any comments, feedback, questions from anybody on taxonomy pieces? Okay, great. Let's jump to the next item on the agenda, which I believe is the consumer token framework that we put together. I'm going to post the link to that in the chat. There we go. So the update there is we have put together a new version. We've compiled all the feedback from the community, refined it, and put it into an updated version. It's still pretty similar to the old one. We've made a few changes here and there. By and large, it's pretty similar. We've also, if you go to the link that I put in there and you click View Framework, that's the actual framework itself. One important difference, I suppose, is this version of the framework, we're testing out getting community feedback, not through Google Documents, but through kind of like a custom interface that we built to do this. We found Google Docs was a little bit difficult to manage in terms of identifying what comments and feedback are kind of most important to people or what people agree with. So we tried to create kind of a basic interface to allow people to provide comments and indicate when they agree with somebody else easily and cleanly, and kind of keep track of those things better. So the goal is to make something a little bit more collaborative, a little bit more friendly for this type of collaboration. So we'll test that out. We'll see how it goes, and the hope is that if this works out well, we can use this for other aspects of the Brooklyn project and related efforts. So in terms of the framework, I think a couple of notable changes. I mean, I'm not going to go through the whole document now, obviously, but number one, I think we tried to incorporate a little bit more specific points, and I think this was in the prior version too, but making sure that parts of the framework contemplate this idea of centrally managed versus decentralized, and that some projects may have parts of either or both, and so we're trying to help projects as well as the communities related to the project kind of parse that out a little bit and be a little bit more clear about which projects are trying to do what from a centralized versus decentralized perspective. It's just kind of a general orientation for those who aren't familiar with what we've been doing on the framework. The idea is we've set out kind of two parts. The first part is principles and practices, and these are just kind of like general high-level principles and practices that we think are important and the project should either strive to achieve or at least think about achieving. We've tried to be not too prescriptive because I think we recognize that this is still pretty early days, and it's anything we say now that this is the right way to do it is probably going to be wrong in 6 months or 12 months or whatever as we learn more how these networks develop. So we've tried to be not too prescriptive, and we try to be clear that, where a project disagrees with a principle or practice, I think what we're most concerned about is that they think it through and that they say, okay, well, here's the reason why we aren't following this principle or practice. And I think that's kind of the a constructive way to approach this, both for projects and as well as the industry and ecosystem generally. The second part of the framework, beyond the principles and practices, is a set of kind of transparency issues that we contemplate, or that we would hope that projects as well as their communities would kind of focus on being transparent about. And again, the topics, they generally track the principles and practices that we identified. And the idea is that we envision a world where, projects and their communities can work together to try to make sure that for the important principles and practices that we see for, that we in the community see for projects, that projects are transparent, and there's an easy way to figure out how projects are approaching those issues. And if there's not an answer to a particular issue, that in and of itself is valuable. That a project doesn't know what they're doing or hasn't thought about it, I mean, even that in and of itself is helpful. So that's kind of the thinking on those. It's in some ways thematic, but in some ways important. But one additional change is, prior version had talked about recommended disclosures. That's what we labeled that second part of the framework previously, that it was recommended disclosures. And I think, what we're thinking now is it's a little bit less of, disclosures, which sounds a little bit kind of, legacy regulatory world. And it's more of kind of collaborative disclosures and open assessments that we're shooting for. And again, the idea being part of what Director Hinman talked about in his speech that Aaron summarized earlier, is this idea that the federal securities laws in the US, as they're currently contemplated, they don't really make sense for decentralized projects. And that's true because there's no central issuer really that should be responsible for making disclosures for the entire network or project. At the same time, I think our current thinking, and obviously subject to change, is that it would still be valuable for projects and the industry and the ecosystem to have a kind of disclosure or transparency regime, but instead of charging one central issuer with being the ones to make the disclosures and keep them up to date, the idea is to have a community-driven approach around these types of transparency issues that we set on the framework. So that's kind of the vision and the thinking. And again, we invite everybody to kind of post comments and feedback on the framework. And I think we're going to leave that comment period open for about 2 more weeks, and then we're going to try to finalize the next version of the framework and go on from there. Any comments or feedback on this topic?
Pat, there's a question from Freeman. Have there been any projects that used / going to use this framework that you would recommend looking at as an example?
It's a little bit hard to answer because at least currently there's no clear way to, quote unquote, use the framework. I think what I would say is a lot of the projects that have done and kind of are doing well, if you kind of look at the framework, I think they've generally done it, whether they did it because they were specifically trying to match up their actions with the framework, or just they had good people involved and approached things well. I think that it could be either or both. But so I guess that's the best I can do on that. And there's currently no way to clearly use it. But I think that's one of the things we're working on, is trying to find ways to help projects more clearly kind of operationalize or use this, as well as engage the community to help them do that.
But I guess the foam project was was animated, or at least their approach to the cell was animated by the framework, right? Would you agree with that, Pat?
Yeah, I mean, I certainly don't want to speak for the foam folks. I don't know if anybody's on, but I think the approach that we've set out in the framework, and again, I think the framework we've tried to be a little bit less prescriptive about here's how you should design and sell tokens. There's some of that in there, but it's also just saying here's a framework for kind of thinking about these projects and thinking through how you approach them and being transparent about the choices that you make. It's a slight difference, but I do think, and I think this is the next topic on the agenda, the kind of the overall thinking and approach of the we've generally been talking about with the Brooklyn project, the idea of kind of structuring consumer tokens and selling them to actual users and consumers, which is somewhat animated by the framework and kind of consistent with the framework. That is the approach that Foam and Token Foundry are doing right now to a degree that really I think has not been done before. I think projects have tried to do similar things in the past and have succeeded, I would say. But we've built Token Foundry has built a lot of operational and process safeguards into the process to try to really achieve that in a way that hasn't been tried before. So I think it's a cool experiment of sorts that Foam and Token Foundry are doing right now.
There's another question. Would you recommend that exchanges use the Brooklyn project framework when determining criteria for token listing?
I guess I would think, I don't know, I hadn't really thought about it specifically. I guess I would think that exchanges, anybody else in the industry or ecosystem, I would hope that the framework is useful for them for whatever purpose they're trying to achieve. At a minimum, to give the framework a read through, and maybe it spots some issues that they want to kind of think through more thoroughly. I think it can certainly be helpful from that perspective. I do think that projects that try to implement the framework will generally be, I would hope, of kind of a higher quality or more responsible than other projects. So to the extent that that's something that's important to exchanges, and I think that could be helpful. But again, it's at least currently, this is really just like a thought process, a thought leadership piece, kind of an open source thing that we're trying to help people think through. And so there's not necessarily a way to kind of quote unquote use it or operationalize it right now. So beyond being familiar with it and helping guide their thinking to some extent, I'm not sure what exchanges would do specifically with it right now.
That being said, I do think that if the blockchain industry rallied around a set of principles, practices, and disclosures, and that became something that's trusted for high quality projects to go about and engage in, then I imagine that could be useful for lawyers so that they could issue opinion letters. That could also be useful then for exchanges such that they could begin to list tokens where they had a clear understanding that what's being sold is not a security. It's more of a digital good or a crypto good of some sort. So I think it would be helpful collectively to kind of get to a point where we had a set of standards or practices, policies, and procedures that are widely supported, and something that lawyers could point to such that they could issue an opinion that if these practices, policies, and procedures are followed, we have some degree of confidence that it's not necessarily a security.
Yeah, I agree with that. I think that's helpful, which is again why we encourage everybody on the call and that may watch this later to definitely give feedback over the next couple of weeks on the framework, even if it's just kind of upvoting or saying you agree with somebody or you like the framework. That's all. It's all helpful. Helps us get a sense for if we're hitting the mark or missing the mark, so to speak, and where we need to focus.
So Kirk just asked another question, which is that he sees huge value in industry self-policing. Could that have relevance in a set of industry standards that emerge and become salient over time? And with use, yeah, I mean, I think we at least heard from the CFTC or some of the commissioners from the CFTC that they're very interested in the blockchain industry engaging in some sort of self-regulation or self-policing. I think the argument there would be, the government and folks within the government, although well-intentioned, they do not know the industry as well as those that are participating in it. And if they can develop a set of best practices, and that can be helpful in just helping an industry mature. We've seen that pattern emerge in other contexts. So, for example, there's been other financial products that were novel, and folks have that were engaging or selling or trading in those financial products have come together and come up with a set of practices, and eventually that's basically become the way that the government begins to view them. The downside or the counter argument against self-regulation is it sometimes can be a race to the bottom. The industry may have just set standards or policies that are a little bit too low as opposed to where they really should be. So it's kind of a mixed bag, but definitely something that's worth exploring. And I think a lot of there's definitely some interest, at least in the U.S., for self-policing and self-regulation.
Yeah, and to follow on that, I mean, maybe it's a bit idealistic, but I think the way I, in my mind, think about this is that generally we talk about regulation, kind of traditional regulation, and we talk about self-regulation, where the industry kind of quote unquote regulates itself. I think that in this space we have the potential to do something that at least in my head, I'm thinking more of like collaborative regulation. The blockchain, I think what it's really amazing at is this ability to coordinate activities and be transparent and things like that. And I think that, and also, the markets for these tokens and blockchain-based technology are really, they're very global in nature. So I think really here what we need more than in any other industry is kind of collaboration among industry, among regulators, among jurisdictions. And I think that, I'm hopeful that that's where this will eventually end up. This being, the industry and maybe, some of the contributions that we can make to it through the Brooklyn Project. So that's kind of where I'm thinking, my current thinking on this is. Okay, we have just a couple more minutes. Let's get off these. Let's knock off these last two things on the agenda. The fourth item on the agenda was selling consumer tokens to consumers. I think we've talked about that a little bit already. We've got some links in the agenda. We've also been kind of getting feedback on that, both for the Brooklyn Project as well as I know Token Foundry is always kind of reevaluating and hoping to improve their process. So please, give feedback there. And as we mentioned earlier, the Foam project is currently doing a token sale following those standards. And so I think that's a really useful test case. So far, it seems to be going pretty well. I think Token Foundry posted a recap of the standards the other day. And I think they had at the time over 2,000 registrants, and about 25% had failed the questionnaire and the processes that they set forth. So that's some interesting data, and I'm excited to kind of see more data as this comes out and help us kind of figure out the best way to approach these things. Anybody have any comments, feedback, questions on that before we move to the last item? Okay, great. So the last item was we were just wanting to identify other important legal, regulatory, policy topics for kind of community engagement, both for the Brooklyn Project as well as just engaging the community. And I think we just envisioned this as something more, see if anybody has any ideas of things that are important to them that might be worth thinking and collaborating about within the community. So I guess I'll just open it up to everybody for that.
Hey, Nathan here. I had a question. Does the Brooklyn project have a perspective on what happens to an investment token in the case of a blockchain fork?
When you say what happens to the token, do you mean like what would happen from a legal perspective?
Yeah. I guess from a legal perspective, I mean, to me, it seems like a secure or investment token couldn't, coexist on two separate chains and still have all the validity associated with it.
Yeah, so I think it's going to depend a little bit on the specifics of the investment token. So for example, I mean, if the token were something that represents equity in a specific company, then I think you would absolutely be right. And I think, it's still very early days from the perspective of that type of token and that type of, equity formation. In general, what I've kind of heard most commonly in that area is that, that equity, the kind of the cap table is still going to be controlled by the company, by some central entity. And so even if there's some fork of a chain where those tokens are represented, the tokens themselves either, number one, don't directly represent a natively digital piece of equity. They just kind of are a digital representation of an analog, equity representation. And if that's the case, then, it's easy for the company to kind of just say, well, we're not following the tokens on this new chain. I think that's really the most common way that I've seen this talked about so far. I don't know if that answers your question, but I guess the one variation of that is if what we're talking about is a token that was, intended to be a user consumer token or a utility token, but it is deemed a security by the SEC or courts or whoever, and there's a fork. I do think probably in that context the token could continue to operate, and that would be fine. I think there are some interesting implications about okay, who is the issuer, who's kind of responsible for things, depending on, what regulations might otherwise be applying. So it can definitely get tricky, depending on kind of the facts and circumstances. But I don't know if that was at all in the ballpark of what you were asking, but hope so.
Yeah, that makes sense for now. I appreciate the answer.
Yeah, no problem. Anything else from anybody?
Yo, just having the music in the background in the cafe. Have you heard anything about the changing laws to regulation crowdfunding, going from 1.07 million to 5 million? And do you think that there's room around there to do security tokens? Kind of selling around 5 million of security tokens could be just what a project needs to really get off the ground. So I'd love to hear if you've heard anything about that. Cheers.
Yeah, I mean, I think positioning a sale or engaging in a sale of tokens that are going to be deemed a security through any regulation or regulatory exemption, whether that be Reg CF or a Reg D offering. You should do that if you know that what you're selling is going to be a security. If your goal though is to really sell what would be ultimately deemed a crypto good or a commodity of some sort, then you run into the risks that we described before. So you can avail yourself of Reg CF, but it seems like, at least in the current view of the SEC, if you do that, you're going to have to wait until your network is, quote, sufficiently decentralized, whatever that winds up meaning, before you can actually use it as a commodity. And the risk for having something that's a security.
Sorry, just to be more clear, our goal is to raise as much money from people who aren't already rich. And so just curious if you'd heard about the restrictions that we're finding onerous are the kind of 1.07 million cap on unaccredited investors investing. So I was just wondering if you heard anything about that and whether things might be shifting. Yeah,
I mean, Reg CF is a great way to raise some amount of capital from folks that are not accredited investors, for the lawyers that, with folks that are not lawyers and accredited investors, basically a fancy legal way of defining what a sophisticated or wealthy person is in the U.S. So yeah, I mean, if that's your goal to sell a security, and you want to sell a security to folks that are not accredited investors or rich folks, then that could be a fruitful way to do it. Whether or not they increase the threshold, I think, is an open question. There's been discussion about that for a number of years now.
Yeah, and a related point is, I mean, there's been some talk too about changing the definition of accredited investor in the U.S., which could, to some extent, have a similar impact. But as Aaron said, I think it's an open question. It's I don't think there's anything for sure about whether and when things will change.
Thank you very much for your time. I appreciate it.
Yep. Okay, I think we've got everything. So thanks everybody for participating. The plan is, I think we're going to try to transcribe this and post the recording and the transcript for everybody to kind of use this moving forward. Hopefully that works. And hopefully we'll do another one of these sometime in the not too distant future as we have more things to talk about. Otherwise, please feel free to keep engaging with us on Telegram or wherever else, and definitely give feedback on the framework and any other pieces of work product we put out. It's really helpful and valuable to hear from you guys. So thanks everybody.
Thanks everyone.
Thanks guys.
Thanks, Pat. Thanks, Aaron.